Committee on Oversight and Government Reform will come to order. Without objection, the Chair is authorized to declare a recess at any time. We're here today because the IRS's current leadership has proven irresponsible and negligent. The IRS can't seem to properly preserve documents or ensure both privacy and security in accepting electronic tax returns. The agency is in desperate need of new leadership to put it on a better course. There are already a number of examples of IRS incompetence and neglect in the past few years, but several incidents in recent weeks have made it clear for the need for further serious oversight and meaningful reform. As millions of individuals and companies prepare to file tax returns, the IRS must ensure its data systems are secure. Last summer, the IRS suffered a massive hack, leaving the tax information of 300,000+ individuals exposed. The hackers used that information to file fraudulent returns totaling something in the neighborhood of $50 million in refunds before the IRS figured out what was happening. But it has been well documented, billions of dollars have inappropriately gone out the door. And the facts surrounding the recent events appear very similar. On January 25, 2016, the IRS detected unusual IP traffic on its network. This turned out to be a coordinated bot attack or botnet aimed at the e-file system. The hacker's goal was to recover taxpayer e-pins, electronic pins, which would have allowed them to steal refunds of innocent taxpayers. Roughly 450,000 unique Social Security numbers were used by hackers and at least 950,000 attempts to obtain these electronic PIN numbers. All told, the hackers are estimated to have stolen more than 101,000 of these electronic PIN numbers. This latest breach raises serious concerns about the security of the system overall, as well as the potential for paying out fraudulent claims. But none of this should surprise the IRS. In the last evaluation of the IRS's information security, the Inspector General in September of 2015 determined, quote, "Until the IRS takes steps to improve its security program deficiencies and fully implement all security program areas in compliance with FSMA requirements, taxpayer data will remain vulnerable to inappropriate and undetected use, modification, and disclosure," end quote. It probably doesn't get any worse or dire in terms of a warning. This level of incompetence is intolerable for an agency where millions of individuals file their most personal financial information. We're also here to discuss the failure of the IRS to properly preserve documents subject to a lawsuit and/or internal preservation orders, as well as FOIA requests. We take FOIA very seriously. The Freedom of Information Act is the public's right to know. It also allows companies and other organizations to access data so they can defend themselves. On January 15th of 2016, the Department of Justice disclosed in a federal court filing that the IRS had erased a hard drive belonging to a former senior agency employee named Samuel Maruca. And if this story sounds similar to things we've heard about with Lois Lerner and others, it is. And that makes us sick. It's disgusting. It has to stop. We're doing everything we can to highlight it. It's inappropriate, and yet it continues. The hard drive contained information subject to FOIA litigation. Despite the lawsuit, an internal preservation order, and the legal obligation to preserve related documents to the IRS, the IRS wiped the hard drive and scheduled it for recycling. This involved a multi-billion-dollar issue relating to Microsoft. The hard drive likely sat in queue and had been wiped up to 4 months after the internal preservation was ordered. Again, after internal preservation in place, then the wiping of a hard drive. We can't say for sure to pinpoint the date because the IRS doesn't know when the hard drive was wiped clean. Hard drives, you go to Best Buy, you can buy them for less than $100. In a multi-billion-dollar situation, this is what we're talking about. But again, this continues to be familiar. In March of 2014, the IRS destroyed backup tapes containing Lois Lerner's emails, which were subject to investigation by Congress, the Inspector General, the Department of Justice. There were 5 open investigations, 2 duly issued subpoenas, and the IRS wiped the data. Here we have another case where people properly filed FOIA requests, and they wiped it again. This is just 1 month after the agency learned that a significant portion of the Lerner emails were missing, and again it happened. As it turns out, in the Maruca case, the IRS, by sheer luck, already copied the hard drive because of a different lawsuit. It wasn't because of competence, it was just sheer luck. So if you look at the IRS, they have roughly $2.4 billion they spend on IT, and it's worthless, absolutely worthless. 60 to 70% of those funds are spent on legacy systems, preserving old things like COBOL and other types of things. But there's still billions of dollars in fraud running through the system. We have a situation we're going to talk about today where there was a reported hardware failure. The story we got is that there was a power outage, but then the redundant power, the backup power, it also went out. How does that happen? Why do you have redundant power if it also goes out? When we asked through questioning about a breach, I put out a tweet pretty quick and said, you know, when this so-called hardware failure, maybe it was a breach. We start to go and probe and have an investigation. We have a bipartisan staff talking to the IRS, and then they say, oh, we should probably tell you about the breach. What breach? You look at the timeline of this. Let's go through this, because this is just days ago. Our committee, Oversight and Government Reform, a week ahead email to the press confirmed that there'd be a hearing on February 11th relating to IRS document destruction and data security. On February 8th, majority and minority committee staff has a call with the IRS regarding the e-filing outage and the status of the Maruca hard drive. The IRS gives an update on how it planned to recover the hard drive and confirmed it had been wiped. After that date, our staff asked about the breach, referring to the e-filing issue. Mr. Milholland, who's here with us today, begins describing the previously unreported and undisclosed breach. The IRS legal staff intervened and said that he was talking about a different event. So we asked for more information about that. The next day, February 9th, miraculously, in the Wall Street Journal, the IRS releases further details regarding the breach in another phone call with the majority and minority committee staff. And shortly thereafter, the IRS releases a statement to the Wall Street Journal regarding the breach. If we hadn't been asking about another incident, we wouldn't have known about this incident. And it affects over 100,000 people. This is a recurring theme. It's totally unacceptable. We look forward to peppering you with questions, and we expect answers. That I'll yield back and now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. I always try to start our hearings by stating what I think we can all agree on. Today, I think we can agree that the IRS should have strong systems in place to properly preserve federal records and to protect its computer systems from cyber attacks. I think we can agree on that. And those are valid goals, and I know that the IRS agrees with them. However, I do not believe this committee has been serving its intended purpose when it comes to the IRS generally. Unfortunately, Republicans have become obsessed with investigating any and every allegation relating to the IRS, no matter how small. I believe this is because Republicans were not able to find any evidence to support their baseless accusations that the White House conspired with Lois Lerner to target conservative groups for political reasons. They also were not able to identify any evidence that Commissioner Koskinen or any IRS employees destroyed evidence in order to obstruct our investigation. For the record, this is our 23rd hearing on the IRS. The 23rd. That is amazing. We have now interviewed 54 witnesses. The IRS Commissioner has testified 6 times, more than any other agency had over the past 3 years. The IRS has produced more than 1.3 million pages of documents from 88 custodians in response to more than 80 requests for documents. Yet, despite this exhaustive, multi-agency, multi-committee, multi-year investigation, this wild goose chase continues and has come up empty. Last year, the Inspector General issued his report and identified no evidence to substantiate Republican claims of political motivation, White House involvement, or intentional destruction of evidence. Specifically, the report found, and I quote, "No evidence was uncovered that any IRS employee had been directed to destroy or hide information from Congress, the DOJ, or TIGTA," end of quote. The Justice Department also conducted an investigation and concluded that, and I quote, "Not a single IRS employee reported any allegation, concern, or suspicion that the handling of tax-exempt applications or any other IRS function was motivated by political bias, discriminatory intent, or corruption," end of quote. The Justice Department also found, and I quote, "No evidence that any official involved in the handling of tax-exempt applications or IRS leadership attempted to obstruct justice, and no evidence of any deliberate attempt to conceal or destroy information," end of quote. Amazingly, none of these findings stopped the Republicans from trying to impeach the IRS commissioner, despite the fact that there is no evidence that he intentionally obstructed our work or destroyed documents. The problem now is that our committee is in a mindset where we are just trying to get the IRS. And unfortunately, the public does not always get a complete or accurate picture as a result. For example, the impetus for today's hearing was a press report that an IRS employee who was leaving the agency had his hard drive erased in violation of a court order. However, we received a letter from the IRS last week explaining that, in fact, the IRS copied this employee's hard drive first. Another example is the outage the IRS experienced last week. The chairman stated that his gut reaction was that the outage was, and I quote, "It really does smell like a hack," end of quote. However, the IRS has now briefed our committee that, in fact, it was due to a mechanical device failure, and there is, and I quote, "0% chance that this was a cyber attack." Yet another example Republicans have focused on is the incident involving PIN numbers that occurred in January. What is not mentioned is that, in fact, the IRS successfully blocked the IP addresses from which this attack was initiated. As a result, this week the IRS confirmed, and I quote, "No personal taxpayer data was compromised or disclosed by our IRS systems," end of quote. They're critical, these are critical facts, and I hope that the public understands them, and any press that are here will repeat them. As I said earlier, this is our 23rd hearing on these types of allegations against the IRS. Imagine instead if we had held 23 hearings on the issue that actually matters to the American people. Imagine if we had held 23 hearings where we brought in drug company officials to explain their skyrocketing prices. Now that's something that we could really help our fellow citizens on and would make a big difference. Going forward, I hope we will use the resources and the authority of this great committee to serve the interests of our constituents. I want to thank our witnesses for being with us today. I look forward to your testimony, and with that, Mr. Chairman, I yield back.
Thank the gentleman. Now recognize Mr. Jordan of Ohio as the chairman of the Subcommittee on Health Care Benefits and Administrative Rules, and recognize him for 5 minutes.
Thank you, Mr. Chairman. The ranking member said that Republicans have had 23 hearings where they are, quote, trying to get the IRS. We're not trying to get the IRS. The IRS was trying to get conservative Americans who were exercising their First Amendment free speech rights. 23 hearings is a pretty small price to pay when you're trying to protect fundamental liberties in the Constitution, for goodness sake. So I want to thank the chairman for this hearing on document preservation, data security. If anyone needs it, certainly the IRS needs a lesson in how to preserve documents. Let me give you a quick little history here. Several years back, Brian Downing orders destruction of orders destruction of documents that TIGTA needs in their audit. The person who was ordered to destroy the documents comes forward, as we want whistleblowers to come forward when they're doing something, when something wrong is going on, comes forward and tells Stephen Whitlock, the then acting director of the Office of Professional Responsibility, and he says, just keep destroying the documents. Fast forward to 2013. Again, the IRS gets caught with their hand in the cookie jar. Lois Lerner, now famous speech, May 10th, 2013, where she goes to a bar association, lies to the American people, says it wasn't us, it was just those folks in Cincinnati. Complete lie. It was folks in Washington orchestrating this targeting against conservative groups. Later that year, later in 2013, Mr. Koskinen is brought in to clean up the mess. In fact, the president himself said he's the expert at turning around institutions. So what's the turnaround been? Chairman just talked about it, right? What's the turnaround been? We had this case with Microsoft, where an IRS employee, Sam Maruka, his hard drive is wiped clean when there's a preservation and order in place not to destroy any records relative to that court case and that investigation. And of course, the one that I think is most important, Mr. Koskinen, brought in as the turnaround expert, learns that Lois Lerner's hard drive has had problems. He waits 2 months before he tells Congress and the American people, and more importantly, under his watch, 422 backup tapes are destroyed after there are 3 preservation orders. 3 orders, one from the IRS, one from Mr. Milholland himself. Don't destroy anything. And what does the IRS do? 3 preservation orders, one from the IRS themselves, one from TIGTA, one from the Justice Department doing a criminal investigation, and 2 subpoenas from this committee. What does the IRS do? They destroy 422 backup tapes containing potentially 24,000 emails relevant to a congressional investigation and a criminal investigation. So there's a pattern here. Now, finally, Mr. Chairman, just to add insult to injury, guess what the Internal Revenue Service did? That very first example I gave you about Mr. Whitlock, who said, no, keep destroying the documents that the whistleblower came forward and said we're doing, guess what happens? I guess at the IRS, you destroy documents, you get a promotion. Mr. Whitlock was just named head of the Office of Professional Responsibility. So, to the ranking member, I think a 24th hearing with that kind of history at this organization is more than warranted, for goodness sake. There is a pattern of destroying records, a pattern of destroying documents, and frankly, a pattern of destroying records and documents when you've been told not to. Preservation orders and whistleblowers coming forward, and yet it continues. And when that happens, some people get promoted at the IRS. Of course we need this hearing, and I look forward to hearing from our witnesses.
Thank the gentleman. Now recognize the gentleman for Virginia, Mr. Conley, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Ranking Member. 23 hearings on the IRS. You know, when you can't prove it, charge it anyhow. Repeat it. Do it louder. Try to suborn the TIGTA to make sure that his audit is limited with direct advice from you and your staff. Accuse people without facts. Hammer it home on your favorite network, and hopefully it will sink in and become true, even if the facts belie it.
Will the gentleman yield?
No. I'm tired of these hearings. I'm tired of insinuation. I'm tired, frankly, of what looks to a lot of people like demagoguery.
Will the gentleman yield?
No, Mr. Chairman, sadly I will not. I will finish my statement. We need the IRS. We need it to be functional. The same people that want to pillory you here today for your performance don't want to take responsibility for the fact they've starved the beast. They've cut $1 billion from the IRS budget. Degrading service, making it very difficult for the IRS to actually do its job. We leave $350 billion on the table every year. Taxes owed but not collected. That could make a big dent in the debt. We could reduce the debt over 10 years by $3.5 trillion without raising anyone's taxes and without cutting any essential services. But we don't want to do that. We don't want to do that because ideologically the IRS is such a juicy target for our base in making the case that you represent the hobnail boot of government on our necks. And why in the world would we want to do anything to strengthen you? And as a result, we have IT systems, according to John Koskinen, that go back to the Kennedy administration. That's 53 years ago. And we wonder why things aren't totally functional. We wonder why IRS is not efficient, fully efficient. We wonder why hard drives crash when the average age of a computer at IRS with 91,000 employees is 7 years plus. In the private sector, it's 2 to 3 years. So to archive stuff, we have to print and save because we can't trust aging legacy technology systems. And this Congress won't reinvest in you to bring you up to the 21st century because that would make you more efficient. That actually might make you be able to better do your job. And dysfunctionality serves our purposes ideologically and politically. So yeah, that's why we have 23 hearings. And we demonize people, and we deny them their Fifth Amendment rights, and we make charges that turn out to be without foundation. It does a disservice to this committee, in my opinion, and I've sat through every one of these hearings. And I began truly concerned. Was this in fact going on? Did IRS in fact target a particular group or philosophy? As the ranking member said, all of the facts tell us no. Was there an aptitude? Was there political tone deafness? Yes. Was there a deliberate attempt by a federal agency to target a particular political group or set of groups because of their political philosophy? No. And you can charge to the contrary all you want, but the evidence trail doesn't tell us that. But it makes for good television, and it riles up the base, and it probably raises money, but it's not worthy of the Oversight and Government Reform Committee. And as the ranking member said, had we spent 23 hearings looking at price gouging on pharmaceuticals, we actually might have improved someone's life. We might have actually helped some seniors better afford the drugs they need. We might have made a contribution to bettering government. But this is a charade. This isn't about making government better, and it's not even really about holding you accountable. I wish it were. It's to pillory you for a political purpose, and I regret that. Now, Mr. Chairman, I do yield.
For you to suggest and try to assign motivation to our attempt here to get at the truth is beneath the gentleman from Virginia. Name one thing that I said in my opening statement that's not true. Name it. You don't have anything.
You don't have anything, Mr. Chairman.
Yes, I do.
I reclaim my time.
Will the gentleman yield? I have a point I want to make about IT.
And the chairman can use his own time because he's got plenty of it and he's more than prepared to use it. I reverse it. I echo what the ranking member said.
Gentleman's time has expired. Gentleman's time has expired.
Okay, thank you.
With concurrence with the ranking member, I'd like to make a point about IT, because I think that is part of the heart of what we're here doing today. Gentlemen, okay with that? I was elected at the same time as President Obama, so use that as a marker. The federal government has spent more than $525 billion on IT, and it's worthless. One of the questions I have here, with an operating budget for the IT sector at roughly $2.4 billion a year, why is it that we have such poor systems? Why is it that we have DOS and COBOL and other things? We got good, hard-working, patriotic people that work at the IRS. I got 4,000 of them in the state of Utah. And they're using an old, dilapidated system. I don't know how they do it. They try to patch and Band-Aid this thing together. And they can't seem to have enough resources. The president puts out a thing saying, I need $3 billion more dollars. We were only $3 billion short. What happened to the other $525 billion? That's a legitimate bipartisan question. It's part of the reason I'm here today. How is it that the IRS goes via the Department of Justice and tells a judge that they don't have these records? And it's not until this committee, in a bipartisan way with the staff, says, where is this information that miraculously they said, oh, we actually do have it? That's a legitimate question. It's why we have another hearing. I didn't even start the week before last thinking we were due an IRS hearing. I yield to the gentleman from Maryland.
I would hope that our witnesses, the questions have been raised by the chairman. I would hope that you would address those. One of the things that all of us, and I know the gentleman from Virginia is one who is an expert in IT and has spent a phenomenal amount of time trying to make sure our government properly functions effectively and efficiently. And the questions that the chairman just raised with regard to the use of old systems when we should be in the modern age are questions that I think are legitimate questions. And so I look forward to your responses. Did you, gentlemen?
I would just add to my friend from Maryland, I couldn't agree more that those are legitimate lines of inquiry, but they have to be balanced with, and what's happened to your budget so that you can make those investments? Has it gone up or down? Has Congress shown a commitment to trying to modernize your IT system so that we don't have this kind of problem? Presumably, we could find common ground. That's a nonpartisan agreement.
It's in my set of questions and why we're having this hearing today.
Except that it isn't.
What do you...
Reclaiming my time, Mr. Chairman, I yield back.
I just have to say, and I'll give you equal time here, for the gentleman to suggest those aren't my questions and to impugn the motive of any member is totally inappropriate.
I would simply say that I didn't impugn anybody's motive. I characterized this hearing and this process. And if the gentleman wishes to take exception to that or offense by that,
I take a deep exception
well,
to it.
I regret it.
It's bipartisan, we get equal time, and there's a legitimate reason to understand why they go to the Department of Justice, represent that they don't have the documents. We ask for them, and then they miraculously say, oh, yes, I guess we do have them.
I think that the chairman can certainly appreciate questioning the process and the 23rd hearing on the IRS without necessarily personalizing it. The chairman knows I do respect him, and I certainly made no attempt to try to personalize it. But would I characterize this process negatively? Yes. I've made no secret of that. And I don't apologize for it, and I don't retract it. And it's not impugning you or any other individual to call into question that process. That's my right as a member of this committee. And I won't be silenced by deliberately trying to personalize it so that the critique somehow is diluted. The critique stands. You don't have to agree with it, Mr. Chairman.
I do not.
But I stand by it.
Let's move on. Let's move on.
Fine, let's move on.
Pleased to welcome Mr. Terry Milholland, Chief Technology Officer at the Internal Revenue Service, Mr. Jeff Turbiano, Deputy Commissioner of Operations at the Internal Revenue Service, and Mr. Ed Killen, Director of Privacy, Government Liaison, and Disclosure at the Internal Revenue Service. I want to appreciate you all being here today. If you will please rise and raise your right hands. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you. You may be seated. Let the record reflect that the witnesses all answered in the affirmative. In order to allow time for discussion, we would appreciate it if you would limit your oral presentation to 5 minutes. Your entire written statement will be made part of the record. Mr. Milholland, you are now recognized for 5 minutes.
Chairman Chavez, Ranking Member Cummings, members of the committee, my name is Terrence Milholland, and I am the IRS Chief Technology Officer and Chief Information Officer. I appreciate the opportunity to testify today. In my role at the IRS, I'm responsible for all aspects of the systems and data that operate our tax infrastructure. We have a 7,000-person information technology organization that maintains 500-plus systems and data and supports the processing of 200 million tax returns annually. Before joining the IRS 7 years ago, I spent 3 decades in the private sector and held a number of information technology leadership positions. My experiences included as Executive Vice President and Chief Technology Officer of Visa International, I was also the Chief Information Officer and Chief Technology Officer for Electronic Data Systems Corporation, and before that, the Chief Information Officer for the Boeing Company. It's an honor for me to serve the public as the IRS CTO and to support the tax system by helping the service modernize its IT systems. This concludes my opening statement, and I'd be happy to take your questions.
Thank the gentleman. Mr. Tribbiano, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, and members of this committee. My name is Jeff Tribbiano, and I'm the Deputy Commissioner for Operations Support for the IRS. I appreciate this opportunity to testify today. In my position at the IRS, I oversee internal operations, which includes information technology, human capital, finance, privacy, procurement, planning, facilities, and security. Prior to joining the IRS in June of 2015, I served as the Associate Administrator and Chief Operating Officer of the Department of Agriculture's Food, Nutrition, and Consumer Services. And prior to joining the federal government in 2010, I held a number of key leadership positions with Fortune 500 companies. In addition, for more than 22 years, I have served and continue to serve our country as a captain in the United States Navy Reserves, to include 3 mobilizations and deployments to the Middle East. My experiences in the public sector, private sector, and military have given me a deep understanding of the importance of public service. I'm especially proud to be part of the leadership team at the IRS and to work for an agency with such an important mission. In my 8 months at the agency, I have found this team to be an amazing organization filled with dedicated and talented people, and I'm privileged to work alongside of them. Turning to the subject of today's hearing, the IRS has been working for more than a year to modernize our records retention practices in regard to emails and other electronic records. We are implementing the National Archives and Records Administration's capstone approach to managing email and are working towards full implementation by the end of calendar year 2016. At that point, our systems will permanently preserve the email records of all employees in electronic format. Our ultimate goal is to end the reliance on computer hard drives of individual employees as an archive record store, and instead use network databases to preserve all records that are electronically generated by the workforce. As we make these improvements for the long term, we recognize we need additional interim measures to ensure we are doing everything possible to retain official records until a more comprehensive solution is in place. This need became apparent when an issue arose in connection with the service's collection and production of documents related to a Freedom of Information Act case captioned Microsoft versus the IRS. In January of this year, the IRS advised the court that we had discovered an issue regarding the computer hard drive of Samuel Maruca, a former IRS employee who we identified in a litigation hold effort undertaken in December of 2014 in connection with the case. Shortly after Mr. Maruca left the service on August 1st, 2014, his hard drive was designated for erasure so it could be securely reused or scrapped in line with the standard IRS procedures. Because Mr. Maruca's hard drive was designated for erasure before the issuance of the litigation hold, the hold did not prevent the erasure of this hard drive, which occurred in late 2014 or in early 2015. However, we do believe the erasure of Mr. Maruca's hard drive will have minimal effect on our ability to complete document production in this instance. We know that Mr. Maruca's hard drive was copied on July 16, 2014, in connection with the document collection being undertaken for a separate litigation. We have therefore determined that the data stored on his computer hard drive up to July 16, 2014 has been preserved. We also have emails copied on Mr. Maruca's network account in July of 2014. And if necessary, we also can access our backup tapes or disaster recovery tapes in order to produce documents. Even so, we recognize the situation reflects a shortcoming in our document controls. Therefore, pending further review of the IRS's litigation hold procedures, the Commissioner has ordered a halt to the erasure and recycling of employees' devices, including computer hard drives and mobile devices, for all departing employees. We will now copy material off the hard drive of every employee who leaves the agency and store that information in a digital format in addition to retaining the physical hard drive. We are also broadening our litigation hold procedures to ensure that hold instructions are provided not only to the pertinent employee, but also to the employee's supervisor. We will also update our procedures for processing employees who leave the service to ensure that appropriate personnel are advised of pending litigation holds and document collection efforts involving the records of custody for departing employees. In closing, I want to assure the committee that the IRS is committed to building on these efforts and to make further improvements and continue focusing on serving the nation's taxpayer. This concludes my statement, and I'll be happy to answer any questions.
Thank you. Mr. Killen, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, and members of the committee. My name is Edward Killen, and I'm the Director of Privacy, Government Liaison, and Disclosure at the IRS. I appreciate the opportunity to testify today. In my role at the IRS, I represent the agency's interests in multiple aspects, including records management, information protection, disclosure, data sharing, and combating identity theft. My office manages relationships with federal, state, and local agencies by facilitation and oversight of various data sharing programs and initiatives. We also work to ensure the protection of federal tax information in the custody of our data exchange partners. The bottom line for my office is that we're working every day to protect taxpayers, safeguard their personal data, and promote both privacy and transparency principles, including the appropriate availability of agency records. I've spent my career in public service, beginning as a Presidential Management Fellow with an appointment to the Social Security Administration. In 2003, I joined the IRS as a policy analyst in our Wage and Investment Division. Since then, I've had the opportunity to carry out a wide range of assignments in different areas at the service, including leadership positions as the Director of Governmental Liaison, Disclosure, and Safeguards, and Senior Advisor to the Deputy Commissioner of Operations Support. I've also engaged in numerous and diverse detailed assignments across the IRS, including stints within our Chief Counsel's Office and the 2008 Economic Stimulus Team. I'm proud of the years I've spent in public service and grateful for the chance to continue to serve the American taxpayer. This concludes my statement, and I would be happy to take your questions.
Thank you. You all seem like decent individuals. The question is, why do we have to keep coming back and asking for the same basic information? The IRS advice to individuals and businesses is that they should hold their own personal business and tax information for how long? How long are you supposed to hold on to your own personal information? Mr. Tribbiano?
Sir, that's not my area. I'm with operations support, so I...
Mr. Killen, how long? How long did the IRS advise you to hold on to your own personal information?
Well, I think it would depend on the particular circumstances, but you know, as a general matter, probably 7 years or so.
7 years. I mean, that's what I've generally heard as well, 7 years. So how long does the IRS hold on to its own data and information? Mr. Maruka leaves the employment. Why the swift erasure of everything that he has? Why does that happen? Mr. Killen?
Well, I think in the particular case of Mr. Maruka, as the written testimony shows, and as I think we'll probably talk through the day, that was largely a factor of sequencing and of particular circumstances. But I think the thing that I would reiterate about that is that essentially we have found the file, the data.
Okay, but yes, did find the file because we pushed the issue, forced the issue, but on January 15th of this year, the Department of Justice, on the behalf of the IRS, actually filed a notice with the federal court that they had erased Mr. Maruka's hard drive. Here's the fundamental problem. You require us, the people, to hold on to their information for 7 years. The IRS erases their information. There's no consequence. Nobody's held accountable. There was an internal preservation order, but it was ignored, and there's no consequence for that, right? Who issued the internal preservation order?
That came from our legal department.
How does that process not hold that information?
The internal preservation order came, it was actually a litigation hold order, came after Mr. Maruka left the agency.
But why did you have, What originally happened is Microsoft filed the Freedom of Information Act request. That was not complied with. So they had to go to court and wait to get a court date and then get the court to try to say, where is this information? And you had already erased it in less than a year. I don't understand why the IRS asks us to hold information for 7 years and you don't even hold it for 7 months. How does that happen? Why does that happen?
Well, Mr. Chairman, it was a timing issue. Again, Mr. Maruka left the agency on August 1st.
But if we have to hold our information for 7 years, how come the IRS doesn't have to hold its information for 7 years?
The information from Mr. Maruka's system is backed up with our backup tapes. It's just harder to get into that system, and Mr. Mulholland can walk through that. It's the hard drive that's easier to access, and that.
Right now today, how long does the IRS preserve its own internal documents? How long?
It depends on the documents. Mr. Killen can walk you through that.
That's true. It would largely, there are various records disposition schedules for different types of records, both across the federal government as a general matter, but certainly within IRS. So it's largely fact dependent, but.
Give me a range. What's the shortest amount of time? What's the longest amount of time?
Oh, it can really vary.
Look, you have a $1.7 billion dispute, and you have the person who's working on the issue. They leave employment for whatever reason. I'm sure it was a legitimate reason. But why is all that information suddenly erased? And how do you go in front of a judge and say, we no longer have that information? How does that happen?
Well, I mean, so certainly
Because neither of those things were true, right? Neither of those things were true. You actually did have the information, but you represented to the Department of Justice that you didn't have it. But it was erased, even though there was an internal preservation order.
At the time that the Department of Justice was notified, we thought that there wasn't information saved. When we went back to take a look at it and to go through the records, we found that we did back it up for another litigation hold up through July 16th of 2014. Mr. Maruka left the agency on August 1st.
Can you help detail for us, and you're not going to be able to get through it verbally now, my time's expired. I have two things that I'd love to understand. How do preservation orders internally work, and why are they not adhered to? Because we had that happen in the Lois Lerner case, we have that happening in the Microsoft case. How does that happen? And then the second thing is, I'd like to know what documents you do and do not retain, and for how long. And I fundamentally don't understand why it's not the same for the IRS as it is for the American people. Could you, between the three of you, get back to the committee on those two topics? Is that fair?
Yes, sir.
Let the record reflect all three of them thought it was fair. All right. My time has expired. Now recognize the gentleman from Virginia, Mr. Conley, for 5 minutes.
And let the record show this member has felt the chairman has always conducted himself fairly. We don't always agree, but I think he's always been fair. I want to talk a little bit about investments in capacity. Mr. Tribbiano, is it true that the agency's inflation-adjusted budget has been cut by 17% since 2010?
Yes, sir.
Is it further true that by 2015, fiscal year 2015, we whittled down your funding, your budget, to the lowest level in 5 years?
Yes, sir.
Is it also true that, in effect, when you count inflation, that means that your budget has the buying power of the budget of 1998?
Yes, sir.
That's a long time ago. The reduction has been about $1.2 billion?
Yes, sir.
And in fiscal year 15 alone, the budget was cut another $346 million from the previous year funding. Is that correct?
Yes, sir.
Well, let me see. Because of these cuts, as I understand it, the workforce has been cut by 17,000 since 2010. Is that correct?
Yes, sir.
2/3 of your top managers have left in the last 5 years. Is that correct?
Yes, sir.
40% of your workforce, by the way, on top of that, is eligible to retire by 2019, largely because of the baby boom generation. Is that correct?
Yes, sir.
Well, do these cuts and reductions have an impact on productivity, customer service?
Yes, sir, it has a direct impact.
Does it impact your audit capability?
It impacts our audit capability and our revenue collection capability as well.
Well, Mr. Mulholland, do these cuts have any impact at all on the technology, the IT budget?
Yes, sir.
How so? You want to elaborate a little?
It affects people, processes, and technology. For example, in the people area, we know that we have 67 people who are the single points of failure, so to speak, for particular systems. If they left, we wouldn't have any knowledge to deal with an issue in a particular system they support. That's how thin we've become, is that we now can identify the places where we are truly thin. So we have to deal with risk mitigations for those particular systems.
So Mr. Koskinen was quoted last week as saying, we got systems that go back to the Kennedy administration. What was he talking about?
What he was referring to are systems like the individual master file or the business master file, where these systems were literally designed and architected in the 60s and rolled out in the 1970s. Those systems are where, literally, your tax returns, the master file record of your tax returns are kept. We've been in underway.
Let me interrupt you 1 second there. So my tax returns might be kept in a system that goes back to the 60s and 70s.
That was architected in the 60s and 70s. That's correct, sir.
What could go wrong with that?
Well, that is one of the many issues that we deal with, is the sustainability of those long-lasting legacy systems, so that every year we can have a smooth filing season.
So when we talk sometimes about retrieving information, archiving information, being able to produce documents or evidence with respect to a court case, we're relying, in many cases, on technology to be our friend that goes back 40, almost 50 years.
Obviously, depending on the case, so to speak, if individual taxpayer data is being accessed, that architecture is that old. The access mechanisms might be more current.
Right.
But the fundamental underlying structure is relying upon systems that were built in that era.
Okay, you come from private sector.
Yes, sir.
You're now the CTO for a public sector entity. Real quickly, in the time I got left, what would you do and what would it cost to do what you'd do to modernize and upgrade IRS so it's functioning as a modern, technology-oriented entity in 2016?
Yes, sir. I'll try to be very brief. We've built a technology roadmap. Did that a few years ago and have been executing against it for the future state, that is to bring the IRS so it looks like a company a digital company in the financial area that is comparable to the way a large financial institution would operate. That means that we have to upgrade a number of the underlying processes which are based in these, as I say, the 1960s architecture, bring them into a 21st century architecture and implement the technology that allows that. We've standardized on modern programming languages, for example. All new developments since I've arrived are in Java, for example, rather than the more ancient languages like assembly language or COBOL or these, I'll just say simply legacy programming languages. We've standardized on a different operating system, in our case Linux, for example, very modern operating system environments that's very common across all of private enterprise. And we've been slowly and steadily migrating new systems of what we've had to invest in to support things like FATCA, the Affordable Care Act, the Revenue Return Program, our fraud detection system. All are built, I'll say, the right way, so that we can slowly remove ourselves from dependencies on these older systems. And then the last comment to make, we have plans to get off, so to speak, of that dependency. The Congress has supported us in our Business Systems Modernization Program and in a program called CADE-2, Customer Account Data Engine. The second transition state of that is underway, in which we're converting off of that master file system into a modern relational database program, at the same time removing the financial material weakness of the older individual master file systems. Let me stop there because I could certainly go on and on and on.
I thank the gentleman. I'd simply ask that the digital roadmap that you're talking about, if you could provide this committee that copy of this roadmap, I think we would both like to look at it. When can you provide that to this committee?
As soon as our release mechanism allows us. I will, soon.
Mr. Chairman,
Get away with that?
if we could also add to that request the cost. What would it
Yes,
cost?
that would be great, because
Thank
the
you.
IRS has had over the last 5 years more than $11 billion in just IT expenditure. It's a
Yeah.
significant amount of money. We would appreciate you sharing that plan with us.
Mr. Chairman, can I add one other thing?
Sure.
The roadmap does not stand by itself. It goes along with a business plan, which we call the future state vision, in which all of the businesses is outlined, how do they want to actually operate in the next 3 to 5 years. And then that roadmap supports that plan. So you'd actually need to understand both.
If you could provide both, that would be appreciated.
All right.
Fair enough? And I appreciate it. Thank the gentleman for his questions. And I'm surprised, after 23 hearings, you still have questions.
It was a struggle, Mr.
Yes,
Chairman.
yeah. You still have questions, and so do we. We'll now recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Chairman, Mr. Mulholland, in May of 2013, the country learns that the IRS has been targeting conservative groups. Congressional investigations are announced. The President has a big press conference. Attorney General announces that there's a criminal investigation that will be following. Did you take any action, as the Chief Information Officer, did you take any action to preserve information, data, and documents?
Yes, sir.
And what action was that?
We issued a directive to my staffs down through every level of management and individuals to hold on to every piece of information.
Was that, was your order clear?
I certainly thought it was clear.
I'm going to read from it. Do not use, do not reuse or refresh or wipe information from any personal computer that is being reclaimed, returned, refreshed, updated from any employee or contractor of the IRS. Effective immediately, the email retention policy for backups is to be indefinite rather than 6 months. Pretty clear, right?
Yes, sir.
You go on in that email to say this. In other words, retain everything. Now, everything's a pretty big universe. So I don't know how you could be more clear. So, the chairman has asked us a couple times, how in the world did you end up destroying, did the IRS end up destroying, with that clear of directive, end up destroying 422 backup tapes that were extremely relevant to the investigation?
As you're undoubtedly aware, having that email, as TIGDA did their report out, they looked at every step of the process along the way of how did we end up doing that. In fact, I think I was quoted in there when they interviewed me as I was literally blown away by the fact that it had happened. Because again, I thought the instructions were remarkably clear.
So I think they're clear too. If I could just interrupt, Mr. Mulholland. So I think they were pretty clear too. So did you do anything else? Did you just send this email out or this directive out that says keep everything, and then that was it? Is that all you did?
Within IT, the Information Technology Organization, we discussed it in staff and with the executive team that we needed to do this. We were also in the midst of consolidating all the email servers that were sitting around the country into our 2 primary data centers.
Let me interrupt again. I only got 5 minutes here. Were there other preservation orders that came to the Internal Revenue Service? Other orders to preserve documents, not just the one you sent out internally, but were there others that come in from the outside?
I really don't know that. We'd have to ask the Chief Counsel about
Yeah,
that.
well, there were 2, right? There was one from the Justice Department, one from TIGDA. They said, hey, they would have just reinforced preserve documents. So did you take any action relevant to those other orders to preserve all information?
I don't recall seeing those orders, so
So no one communicated, when the legal staff got the order from the Justice Department, preserve all the information. You didn't take any, they didn't say, hey, you better make sure we don't destroy anything. They didn't communicate to you, and then you didn't communicate another email like the one we were just talking about.
I'm totally unfamiliar with the order that you're discussing. We always have the practice generally, when a request comes in that council needs us to hold on to items, they send an email around to the responsible individuals and tell them to literally, sorry, go ahead.
What about the subpoenas? This committee sent 2 subpoenas. Did that warrant, or did that trigger you taking any further action than this one email that you sent?
No, sir.
So the two subpoenas and the other two preservation orders, the IRS Chief Information Technology Officer, that didn't trigger you to do anything else. You sent this one email that I think is pretty clear, but that's all you did.
As I tried to express earlier, Congressman, we discussed the request to hold on to all of those items that were in that email throughout our staffs.
Yeah.
So the executive team and the management team would understand how serious this was, and therefore to protect basically the retention of information.
I got it.
So
I got it.
it was reinforced constantly to do so.
So then why wasn't it? So there's two key questions. There's two questions, and I've got 30 seconds here. Two questions. One, when you say keep everything, and then 422 tapes, 24,000 emails are destroyed, I want to know how that happens and why that happened. Second, I think this is a question I get all the time from folks back home. Who was held responsible? So there's an order given from the Chief Technology Officer to keep everything, and it's not kept. In fact, it's destroyed. Who was disciplined? Who was held accountable? That's what we would like to know.
I'll answer the second question first. I held myself accountable, as it was reported in the TIGTA report, that it starts at the top. I was at the top, and therefore myself and my management chain had to be held accountable. That was part of our performance plans and such, and was discussed appropriately when we discovered this particular incident, what had happened.
Did you get let me just ask you one other question. Did you get a raise the last few years? Have you had a raise in your salary?
Because I'm in the senior critical, I've got an adjustment because of this senior
Your pay
critical
go up?
Yes, it did.
The last 2 years?
I think only once in the last 2 years.
Who's your direct boss? Who do you report to? When I look at your chain of command, it looks to me like you report to Mr. Tribbiano.
Mr. Tribbiano.
And Mr. Tribbiano, your office is a direct report to the Commissioner of the IRS, is that right?
Yes, sir.
All right, so what happened there? You find out this guy does an order that's as clear as it gets. Retain everything. It's not followed. Tapes are destroyed. 24,000 emails. That information comes to you. What did you tell Mr. Koskinen?
Well, sir, I was not part of the IRS during that time.
What did your office tell Mr. Koskinen?
I do not know what my office told Mr.
You
Koskinen.
come to the hearing, you know we're talking about record retention, you don't know what happened?
I didn't say that, sir. I said I wasn't responsible and I was not there.
Gentleman's time has
you, Chairman.
expired. We'll now recognize the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you, Mr. Chairman. Understand that we're here talking about what we loosely call data preservation and security, but we're doing so for the IRS, where the data that we'd most want to keep to ourselves is to be found. And I've often wondered how the IRS is able to attract the advanced technical professional employees to do what needs to be done. You know, it's easy enough for us to tell you what you should do. So I'm interested in exploring what we can do to make it possible for you to do what you're supposed to do. Now, what intrigued me was this notion of critical pay authority that allows the IRS, other agencies have it too, to hire people who would be very difficult to attract to the public service otherwise. Do I understand, Mr. Milholland, that you are a critical pay employee?
Yes, ma'am.
Is it fair to say that in order to come to the IRS, you took a pay cut?
Yes, ma'am.
Would that have been a significant pay cut?
Yes, ma'am.
So when we look at how important this data is, I wanted to see how many people were in this position. I understand that you're authorized to have in these critical positions, that the IRS is authorized only for 168, only for 40 at one time. I am quite amazed at that. And that even they can only serve 4 terms. You'd be lucky to keep them for 4 years. You'd be lucky to keep them for 4 years when you consider how critical these people are. We do HB1 visas. They're so critical in our own country. Is my information correct that there are only 19, Mr. Milholland, of these critical technical people at the IRS at this point?
I can answer for the number in information technology. There's 11. I believe Mr. Tribbiano can cover the rest.
Yes, ma'am, we have 14, and I'd just like to note, ma'am, that we don't have that authority anymore. That authority expired.
Well, that was going to be my next question. I understand that this number, since they can only stay 4 years, that number is depleted every time you get to the end of the 4-year term, and that person, that critical person, even if they haven't already left to go to some high-tech company, has to go then.
Yes, ma'am.
And you've had no authority for at least 2 years
Yes,
to
ma'am.
hire people. That's why you're down to 19,
14 in total.
14 for you, Mr. Tribbiano, and,
No, 14 in total for the agency, ma'am.
oh, for the entire agency, out of 160 that are 68 that are authorized.
Yes, ma'am, we lose 1 this year, and then the remaining 13 next year.
This is malfeasance, it seems to me, but it's on our part. I don't know how we could have gotten without at least authorizing. I don't know if there's enough funds, even if authorized. But if you are able to even attract such people, you deserve our congratulations. But if we can continue to reprimand you for things you don't do in data collection while we don't recognize our responsibility to authorize you to have what I regard as a very small number of technical professionals on board, then there's a disparity here that I think the government has to take accountable.
Will the gentlewoman yield?
Yes, sir.
My understanding of this process is that the Office of Management and Budget has the opportunity to offer 800 people within the federal government critical pay authority in consultation with the Office of Personnel Management. Of the 800 available slots for critical pay authority, they're only using 4, not 400, 4 of the 800 that
Where
are
is
already
this,
on.
in this agency?
We'll get you that throughout government. So if the IRS commissioner needs critical pay authority, for instance, for IT specialists, which I would probably actually agree with, there is already a process and authorization in place where they simply, OMB with OPM, goes and gets that authorization.
Well, I understand they don't even have to go through OPM, that is this authority that you think the agency needs?
Yes, ma'am. Streamlined critical pay is very important to us. We were able to.
But do you think you have the authority? The chairman thinks you already have the authority.
Not under what we had before, which is streamlined critical pay. What the chairman's referring to, I believe, is if I understood right, is an OMB, an OPM process that exists for critical
But
IT.
the people we're talking about don't have to go through that process, do we?
Streamlined critical pay, no, ma'am. We
Yeah.
wouldn't
So
have
it's
to. We can
treat-
recruit directly from the private sector into the top IT positions.
If the gentlewoman will yield, if the IRS has a case, the mechanism that Congress previous to me had set up is that they make the case to the Office of Personnel Management or through the OMB. In concurrence, they can grant that, all within the executive branch without having to come to
But
Congress.
it expired 2 years ago.
No, I believe it's, well, I'll work with the gentlewoman to help clarify this, but I do believe it is currently available. Gentlewoman's time has expired. I'll work with the gentlewoman on this topic.
I wish you would, because the testimony has been pretty direct here, that it has expired, and our own research shows us it's expired.
Okay. Well, again, we'll be happy to work with you. We now recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman. And just in reference to statements made earlier by a member of our committee concerning several senior-level administrators leaving under the guise of the challenges of doing the job here. Remember, some of those left under a rather dark cloud, pleading the Fifth, under potential impeachment, et cetera. So we don't need to forget that also. Mr. Milholland, you mentioned that when finding out that your direct orders for preservation were disregarded, you were blown away. Coming from your experience in the private sector, extensive experience and background in the private sector, I would assume that orders like that wouldn't have been disregarded clearly without significant consequence. So I do want to go back to a question made by a colleague of mine, Mr. Jordan, and just get a more direct answer. Do you know of anyone who was reprimanded for not following the preservation notice? Reprimanded or worse?
The way we handled the situation was waiting until after the TIGTA report was in, where we're basically, as I say, the TIGTA concluded there was no criminal wrongdoing, which was peace of mind that someone did not deliberately set out to do this. And then in reading through their report, what conclusion you had come to. As I say, management, me, took accountability for our management chain's failure to see that the instruction was followed. That then was dealt with through performance reviews and feedback to people for their whole entire performance through the appropriate chain and such. We did not penalize or punish anyone on the floor because they thought they were doing what they were supposed to do. They had received instructions that were following a process, and
But leadership team, anyone reprimanded?
it was in the sense of in their performance review feedback, yes.
But no other consequences?
No other
Beyond that.
consequences, no, sir.
I doubt that in the private sector it would have been as simple as that. Let me move on. The Taxpayer Advocate recently released a report on the IRS future state plan that stated the IRS's intent to move all taxpayer filing and help systems to an online platform. In the last 9 months, the IRS has experienced at least 2 electronic data breaches surrounding taxpayer P2s. This includes the May 2015 breach that exposed more than 100,000 taxpayers' sensitive information. The Taxpayer Advocate also found that roughly 1 in 5 taxpayers who are victims of taxpayer identity theft had the IRS files closed. Despite unresolved issues remaining, taxpayers, in other words, still had to wait an average of 6 months before the negative impact of taxpayer identity theft was addressed. Mr. Tribbiano, in light of these breaches, why does IRS feel that now is the best time to roll out a more expansive and pervasive online tax system?
Sir, if I can just add one thing to that, we're not abandoning and going everything to digital or to online. We still have to take care of the taxpayers that still want to file paper returns and go that route. But the customers in this case, the taxpayers, have advocated for us, or for the IRS, to operate more as a large multinational type of bank and be able to do things online. As you could imagine, they'd rather deal with us online more so than deal with us in person. So we're shifting. It's a 3 to 5 year process to go to where we want to go in what we call future state. And that's to be able to have interactions with the taxpayers electronically the way they're asking for it.
How do you propose to protect them, though, online?
We're building, as we build out the technology, we're changing and adapting it, and I think Mr. Milholland can walk you through some of the things.
Walk me through that, some of the means by which you can stop the data breaches that could very clearly come, that's taken place not only online, or that's taken place in person, but it could take place extensively online.
Yes, sir. We've have an initiative we call the E-Authentication, Authorization, and Access Initiative. The first part of this is what we're doing to bring Get Transcripts back online. If you recall, with that original issue from last May and June, we took it offline until we could get it right. That is the underlying authentication. Can we really identify that the individual who's coming in is who they say they are? That work is underway. We hope to roll that application back up sometime this spring. But we also have done other things that we started changing the way that we handle, I'll say, the online environment. The particular technologies we in fact deployed as a result of the Get Transcript incident were in fact what allowed us to stop this bot attack from 2 weeks ago explicitly. ability to capture and see that this attack was ongoing as a direct result of us improving that environment. A number of other tools and such are built into our cyber investment plan. It's what we're going to use. Some of the monies that are now made available to us from the Congress through that extra $290 million, about $100 million of that has been assigned to IT, specifically for cyber. That's where the investments will be made. The President has certainly recognized it in his fiscal year 17 budget submission for what he wants to do across the administration, and then part of those monies will be used to improve aspects of the IRS online presence. There's a number of specific tools I could talk about here, Congressman. I don't know exactly where you want me to go.
Well, I appreciate getting this on record of what you're doing, and that down the road we won't be blown away by mistakes that come. But want to make sure that this is taken care of. That's part of our oversight. We want to make sure that you're doing the oversight as well.
Gentleman's time expired, and if Mr. Mulholland can continue to provide us, the committee, with what they're doing in that regard, we would appreciate it. We'll now recognize the gentlewoman from New Jersey, Ms. Watson-Coleman, for 5 minutes.
Thank you, Mr. Chairman. Mr. Mulholland, it's been almost 4 years since the committee launched its investigation of the IRS, and to date, IRS has produced more than 1.3 million pages of documents from 88 custodians in response to over 80 document and information requests. According to information I have, on June the 3rd, 2015, the IRS's senior privacy official testified before this committee. Is that you, Mr. Killen? Is that you?
Not at the time.
Okay, thank you. Well, let me read to you what was said. More than 250 IRS employees have spent more than 160,000 hours working directly on complying with investigations at a cost of $20 million, which also includes the cost of adding capacity to our limited information technology systems to accommodate the voluminous information requests. And that figure does not include that at least $2 million additional dollars have been spent by the Inspector General. Mr. Mulholland, what sort of capacity has been added to the IRS information technology system in order to accommodate this information and this investigation?
There's an investment plan to build out the entire process of record retention. This ranges from saving all of the email and all of its attachments, the archiving of information that are on hard drives, in turn being saved. And the first elements of this, if we're able to complete our project, would start to roll out at the end of December, beginning of January.
Do you have the resources and the personnel to be able to accommodate this effort?
At the current moment, we do not. We have what we need to implement toward the end of this year, but for the long-term needs of the record retention initiative, to do everything that is being asked in the sense of build a system that can search for anything and do it instantly, that has not yet been, I'll say, completely planned out, nor staffed, nor resourced.
You have made some improvements because you were able to detect some suspicious behavior most recently in the system. And you don't have any reason to believe that that was anything terrorist-related or anything of that nature, or?
Are you, ma'am, are you referring to the bot attack that was 2 weeks ago? I can't speak to who it was. There's an investigation going on right now by the investigative side of TIGTA. This was done from international sites using malware placed on individual machines and servers that attacked the IRS, attempting to get these e-file pins, no other taxpayer data. In fact, the e-file pin is not taxpayer data. So I can't characterize who they were. They were more than likely criminals, but I can't really say.
After Mr. Maruka's file was detected, after there was this belief that it didn't exist, and then you found out that you had a backup to it, you all have done, you've done something that would ensure that this problem doesn't occur in the future until you can take care of it in a more technologically savvy way. You've made decisions that no information gets erased until after something happens, right? Until after what happens, and when would that happen?
Is that a question toward me? I just wasn't sure.
Or to whomever can answer.
I wasn't sure it was to the Deputy Commissioner.
Well, if the Deputy Commissioner is the one that should answer it, I'm fine
Okay.
with that. Thank you.
The answer to that, ma'am, is yes. We put a non-destruct order in for all hard drives and devices for all employees of the IRS when they depart the IRS. And we immediately back up the hard drive itself electronically, so we would have 2 copies until we get to the long-term solution that Mr. Mulholland was talking about.
So minimally, would you say that you have a future desire to hold this information as long as we're responsible as citizens to hold our information at 7 years, that incredible 7 years that we're talking about, or is there something other that you all would be presenting?
Well, I think that's a question for Mr. Killen.
Mr. Killen?
Thank you for the question. Yeah, we are working vigorously to ensure that we migrate our records management practices from sort of the current state to where we need to get to, in the future in order to be compliant with all the respective guidance that's out there from NARA and from OMB. So principally, we've taken, really a multi-pronged approach at that. Mr. Mulholland and Mr. Tribbiano have both talked about various aspects of that, but I think first and foremost, again, ensuring that we no longer wipe or sanitize existing hardware, ensuring that we have the copies that are in place of the machines. But we are, in addition to that, we've put a process in place for our senior-most agency officials throughout IRS at the executive level, because those are the individuals most likely to create federal records. And so we have an approach that we have implemented called the capstone approach to ensure that we maintain and appropriately archive those records of our senior-most officials. At the same time, we are currently in the process of implementing a plan for December 2016, where all IRS employees' email accounts will be archived electronically, and that's per directives that we
Thank you,
have from
Mr.
OMB.
Killen.
Gentlewoman's time's expired. How convenient.
going to
December
acknowledge
of
that. Thank you, Mr.
2016, then we'll start that process. There we go. All right, we now recognize the gentleman from Tennessee, Mr. Desjardins, for 5 minutes.
Thank you, Mr. Chairman. Mr. Mulholland, did the IRS hire a new director of the Office of Personal Responsibility in the past year?
I actually do not know.
Mr. Tibliano?
We transferred an individual into that office.
Who was that?
That's Mr. Whitlock.
Mr. Whitlock, okay, and that's basically the director of the IRS Ethics Department, correct?
It can be categorized as that, yes, sir.
Okay, did they review this individual's history with the department?
With the Department of Treasury, I'm not aware, sir.
Do you know why that the individual's record wouldn't be reviewed prior to hiring someone for this position?
Why it wasn't sent to the Department of Treasury?
Why they wouldn't review his record before hiring someone to oversee the IRS's ethics department?
The Executive Resource Board would have reviewed the record before making the recommendation of the movement of that individual into that position.
Okay, Mr. Mulholland, did that ring any bells? Are you aware of Mr. Whitlock?
Not at all, sir.
No knowledge
No, sir.
of him? It wasn't run by you, Mr.
sir.
Killen?
No, sir.
No. Okay, so the IRS hires a new director to head up their personal ethics program, and Mr. Tribbiano, are you aware that he has a history of illegally shredding documents?
Sir, I am aware that well, first let me say I can't discuss, there's an IG investigation, but our internal review that was done in 2005 found that Mr. Whitlock, there was no intent from that office and that there was no wrongdoing in that process.
Okay, well, I've seen different reports. Mr. Mulholland,
would you be blown away if you learned that you hired an ethics director that had illegally shredded documents?
I'm not,
Just for the record, this position does not report to Mr. Milholland. The position reports to the Deputy Commissioner for Service and Enforcement.
Okay, so you have not reviewed the TIGTA audit of the OPR that was completed while the individual was destroying taxpayer records, or you haven't read the investigation report, or the record destruction, or the whistleblower retaliation?
No, sir. What I reviewed was our internal review of the process that happened. Again, I can't discuss the TIGTA investigation, and our internal review showed that there was no wrongdoing by that individual. That individual did not order the destruction. That was done by the acting director at that time.
Okay, I guess I'm just kind of shocked that, this is a person that the IRS hired to be the head of their Office of Personal Responsibility, and he's got this history, and no one on the panel today seems to know anything about him.
He was transferred, sir. He's been part of the IRS. He was in there as the deputy director of that office, was transferred to head up another office for us, and then was transferred back in.
Is this typical of how the IRS handles new hires?
It was a transfer, sir, not a new hire. He's been with the IRS.
So when somebody gets in trouble, they transfer them around? Is that how it works?
I'm not saying that, sir.
Okay.
Will the gentleman yield?
Yes.
Mr. Tribbiano, you said there's a new non-destroy policy. When did that come into place?
That came into place right after we found out that we had that gap with Mr. Maruka.
That you had destroyed things that, so can you give me a specific time?
January, sir. I don't know the exact date.
So just
It
in
was
the last
January.
30 days?
Yes, sir. When we realized we had the gap, when Mr. Maruka left the agency before the...
Why didn't you put this into policy, when Mr. Milholland put this into place in 2013? Did you ever lift that non-destruction order, Mr. Milholland?
I've never lifted the non-destruct order for the tapes, the backup tapes, which we were dealing with at the time.
Gentleman from Ohio.
The chairman asked my question. When was the order rescinded that you wrote in 2013, which says effective immediately email retention policy for backups is to be indefinite? So if it's indefinite, is that still in place?
Yes, sir, email is saved indefinitely.
But the key question is, what about the backup tapes? They're saved indefinitely?
If the gentleman will yield, it says, do not destroy, wipe, or reuse any of the existing backup tapes for email or archiving of other information for IRS personal computers.
Okay. And our question is, was that rescinded in any way?
If I understand your question correctly, sir, no. What we have, we
Okay,
go back
if I
up,
could, then if it
email and, I'm sorry, I'm interrupting you.
No, if it wasn't rescinded, then why'd you have to issue a new order that Mr. Tribbiano just referenced?
I believe what Mr. Milholland was saying is that...
So you could have another one that people won't follow? I mean, that's our point. If you have one in place, obviously wasn't followed, you said nothing's being rescinded. Mr. Tribbiano said just last month we issued a new order to preserve all documents, not destroy anything. Why was that necessary?
The order that Mr. Milholland was referring to was the one that he did that was about backup tapes and disaster recovery tapes. What we're talking about is the cleaning of hard drives for recycling back into the IRS system for computers or for destruction when they go out. And the reason that's in place is because some of those hard drives contain 6103 data, so we can't leave them around. Now, for longer periods, we have to secure them. So now with the new order, we have to secure those hard drives, put them in a secure location, document them, and put them away because it has information on them.
And their time's expired. We're going to recognize Ms. Kelly here, but that's not what Mr. Milholland's memo of May 22nd, 2013. It says, do not destroy, wipe, reuse any of the existing backup tapes for email or archiving of other information from IRS computers. Further, do not reuse or refresh or wipe information from any personal computer that is being reclaimed, returned, refreshed, updated from any employer or contractor of the IRS. I mean, it could not be more explicit.
What that would, again, Chairman, if I may, That was referring to our backup tapes of the email systems and all the information.
You can dance around this all the time. You had a reservation order in place. You had a do not destroy, and you continued to destroy them. You have represented to the Department of Justice and to the courts and to the United States Congress that you're not doing this. This issue has never been fixed, and that's why we continue to have these hearings. We've gone way past our time. We'll recognize the gentlewoman from Illinois, Ms. Kelly, for 5 minutes.
Thank you, Mr. Chair. Mr. Killen, I wanted to talk about what the IRS is doing to ensure that document preservation measures are being implemented so that we do not end up here again, which no one wants. It seems strange that we're having a full committee hearing because of one employee's hard drive, especially since all but 2 weeks of his emails were preserved. What is the current IRS policy with respect to document preservation for departing employees, and how long are their emails kept?
Thank you for the question. As I stated a little earlier, we have essentially a multi-pronged strategy and approach that we're taking with respect to email. First and foremost, we have implemented the capstone approach, which is an approach that has been developed by National Archives that is focused on your role within the organization. Because you want to ensure that the senior-most officials in an organization who are most likely to create records, that those records are preserved. And so about a year ago, we implemented that process across IRS to ensure that our senior executives all across IRS, that we had the appropriate electronic preservation of those emails. And so that has been in place for the last year, and that was really one of the significant early pieces of the strategy.
And how long are they kept?
They will be kept for our senior. There's ranges, but for our most senior executives, they will be kept permanently. For sort of our second tier of executives on down, they will be kept for 15 years. And that is very consistent with a role-based approach, because you want to ensure that you have the preservation of records, in a most appropriate fashion. Sort of the second piece of that strategy related to email is that by the end of this calendar year, by December 2016, consistent with the directives that we have received from OMB that applies across the government, not just to IRS employees, we will ensure that all of our employee email is available in an electronically accessible environment. And then we are also taking a variety of other steps to shore up our other processes and procedures with regards to records retention for separated employees and for an entire gamut of issues that we're working towards. So we're making significant progress.
Okay. What is the IRS doing right now to ensure that an instance such as a Maruka case does not occur again?
Thank you for that question. So again, as part of sort of the multi-pronged strategy that we have, because the key issue with Mr. Maruka is he's separated from the service.
Right.
And so we have a process in place now where if an employee separates from the service, we're ensuring that we do not wipe the machine. In addition, we are making the copies of the machine. So really, our whole approach around records management and retention is first and foremost ensuring that we follow the relevant guidance and directives that are out there. But then secondly, trying to build in multiple layers of redundancy so that we do what we can to reduce the likelihood of the human element where people make mistakes as well.
So would you look at this as your longer-term solution, or do you have other longer-term solutions as it relates to hard drive inventory management?
There's a very long-term solution because you can imagine the volume of records, and particularly as just in all walks of life, as we move more towards a digital environment. And so our first focus and emphasis is on email. We have paper records, as you might imagine, that we do a pretty good job of maintaining, but we have improvement opportunities there as well. But longer term, there's guidance that talks about by 2019, the federal government should be able to migrate to a place where all records are stored in that accessible electronic medium. Our focus is initially on email, but that will extend to all of the various avenues of record creation towards that 2019 directive.
And once you get there, will this allow you to answer inquiries from Congress faster or FOIA requests? Do you feel like you'll be faster at that?
It will certainly help. It will certainly help because the first thing is that the documents have to be available, certainly. But when you get beyond the actual availability of the documents, and when you talk in terms of document production, you also need to have the ability to search. And ideally, you would want to have the ability to do keyword searches, because those are the things that allow you to have very efficient document production. So my answer to your question is that having the documentation retained is a necessary predecessor first step. But there's also the need to have the ability to do adequate search, find, and redaction capability, and that will be a separate effort. But it certainly is one that we have our eye on as well.
I'm out of time. Thanks.
Thank the gentlewoman. We'll now recognize the distinguished and always dapper gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Chairman Chaffetz, I appreciate your leadership on this issue, as I do Chairman Jordan's, and for that reason, I would like to yield to the gentleman from Ohio, Mr. Jordan.
I thank the gentleman. Mr. Milholland, who told you to issue the May 22nd, 2013 order, or I think directive is what you called it?
The email we talked about earlier, sir?
Preserve all documents.
Yes.
In other words, retain everything, that email.
That was a request that came from Chief Counsel's office, and the way to do it was to send an email out as quick as we could to the people involved with dealing with the backup tapes and such.
And when you did that, did you have just a couple people you were sending it to, or is it send everyone, send all?
It principally directed to the operations team who deal with the backup tape processes and such, but the IT staffs all knew about it.
So in the chart that I see, that you got five agencies or 5 groupings that answer to Mr. Tribbiano. Were the heads of all 5 of those groupings sent your email plus all your staff, or just within your area?
It was just within IT.
Okay. Just want to be clear. And do you know if the commissioner at the time, Commissioner Warfall, knew about your directive to preserve all documents?
I'm pretty sure he did, because this was one of the subjects we were talking about, how we were going to protect the data.
Okay, and then when Mr. Koskinen came on board, do you know if he knew about the directive that was in place, and as you've testified today, still in place? Did Mr. Koskinen know about that, and does he know that it's still in place today?
I can't testify to that, but can I add one correction to my earlier statement?
Sure.
Okay. As I tried to say earlier, it may not have been very clear, that was intended to cover backup tapes for email and anything to do with anyone's information that dealt with attachments, calendars, and such. At the same time, we also were not allowing hard drives to go anywhere. We, in fact, locked up all of the TEGE employees' hard drives in a cabinet, so to speak, so they wouldn't go anywhere and such. During the Windows 7 implementation 2 years ago and such, basically because of budgetary problems, we went and asked, hey, if we copy all the hard drives we've been saving, can we now reuse them so that we can implement Windows 7? And we got permission to do that. So in that sense, those non-TEGE hard drives were reused. So in that sense, they were rescinded.
Yeah,
I hope that's clear.
Yeah, but I mean, it's not, but a lot of stuff you said there, but nowhere in there did you talk about still how the backup tapes, which you said your order applied to, were actually ultimately destroyed. So that didn't cover what you just described. At least I didn't think so.
No, sir. I thought I responded earlier describing how that happened through employee mistakes.
Okay, well, we obviously know mistakes because you gave an order, it wasn't followed, and tapes were destroyed, and information and data that's important investigation was lost. I'm going to go back to the question I asked you the first round. I want to be clear. So you received a bonus this year and last year?
No, sir.
You said your pay went up, so it wasn't a bonus?
No, I'm capped salary-wise. I don't receive a bonus.
How about this management team you referred to when I asked, how this could happen, that tapes were destroyed in light of your order, in light of your directive? Were anyone on your management team, did they receive a bonus this past 2 years?
Yes, sir.
They did?
Yes, sir.
And do you okay that, or does that go up through Mr. Tribbiano and then up to the commissioner?
It certainly comes through me. I believe it goes to a committee Mr. Tribbiano sits on called the Executive Review Board.
Mr. Tribbiano?
Yes, sir. It starts at the division head area, so Mr. Milholland would gather up performance awards, not bonuses, and they would make those recommendations coming forward. I would get them, either I agree, disagree.
Performance awards result, if you get a performance award, that results in additional pay?
It results in a performance award. So yes, sir, your pay, not your pay salary pay, but your cash.
You get more money?
Yes, sir, but not, it's not on a continuous basis. It's a one-time performance award.
Mr. Milholland said he takes responsibility for the fact he was blown away when this happened after his directive. His pay is topped out. He can't go any higher. And the people on his management team who were responsible for the directive not being carried out and for the backup tapes being destroyed all got performance pay increases. Is that accurate?
I have to ask Mr. Milholland if he put them forward in that fashion.
Not all the managers and executives who report to me got pay increases or bonuses. I don't recall explicitly in the chain that led down to where this incident occurred what the actuals were.
But many of them did.
Will the gentleman?
Probably, but I really don't know, sir.
Be happy to yield back.
Gentleman's time has expired. Will you provide that to this committee, Mr. Milholland?
If I'm allowed to legally, I don't know if I'm allowed to release
Well, when the
personal
United States
information.
Congress asks you, you have legal authority to provide that information to Congress. There's nothing classified about people's compensation and bonuses. Would you agree?
Not to me, sir, but I'm not a lawyer, so.
Well, there's some positive qualities. I appreciate that. That's a real plus in your column. I get it. I'm asking you all to provide this information to this committee.
Yes, sir.
Thank you. We'll now recognize the gentlewoman from New York, Ms. Maloney, for 5 minutes.
Thank the gentleman for yielding. And I would like to talk about another outage that was treated differently than one recently at the IRS, and that was one that many New Yorkers were concerned about. It concerned the New York Stock Exchange on July 9th of 2015, and a number of my employees or my constituents work there. And this suffered an outage that completely suspended all financial trading for roughly 4 hours. And this committee sent letters to the SEC and to the Stock Exchange trying to understand the circumstances surrounding the outage. And they both briefed our staff in July, and they told us that a software problem, it was basically a glitch, caused them to go offline in order to respond and to solve the problem. Now, the Department of Homeland Security, in response to questioning by this committee, reported that there was no suspicious activity, and the FBI saw absolutely no reason for any type of enforcement action. And since the committee received those briefings, we saw no reason to hold a public hearing or to hold an investigation, since everybody involved said that it was merely a glitch. Yet we are going after the IRS today for a similar temporary and subsequently resolved website outage. And I just feel that there's a little bit of an unequal treatment here, and I think we shouldn't have unequal treatment. I mean, if you're going to, I don't suggest that the New York Stock Exchange should come in for a hearing. I'm suggesting that we shouldn't be having a hearing on a technical outage for any organization, the IRS seems to be getting a little unequal treatment on this. And I'd like to elaborate, Mr. Mulholland, to ask you about an incident earlier this month when portions of the IRS website were shut down for roughly 30 hours. And I understand that some members of Congress thought and questioned, and rightfully so, I think, in the world we live in, that it was a cyber attack. But the IRS briefed our staff earlier this week, and they told us that this was definitely not a cyber attack. They told us, in fact, that it was just a mechanical hardware failure, similar to what happened at the stock exchange, a glitch, a hardware failure. Now, is my description of what happened to the IRS somewhat correct?
Yes, ma'am.
So this was not a failure of an IRS information system, but just the failure of a singular piece of mechanical equipment, correct?
That's correct, ma'am.
And can you describe what sort of hardware we're talking about?
Yes, ma'am. Yes, ma'am. On our enterprise server, which is the primary engine for processing tax returns, it's made up of various components, including a storage subsystem, which has voltage regulators in it. Now, while the root cause analysis is still underway, it was those voltage regulators that failed. They are a mechanical component that are under somewhat high stress conditions when the computer is operating, and over time, one of the modules that had held the voltage regulators literally said, "I'm failing," called for an alert to the mechanic, that is the technician, to come and fix it. During the process of attempting to fix the mechanical device, the redundant voltage regulator module also failed. Then it took time to restore the equipment to its natural state, bring the system back up so tax returns could be processed. Total outage time was roughly about 30 hours. No software was involved, no microcode. This was, with absolute certainty, not a cyber attack. It was a failure of mechanical devices. What we're most interested in is the root cause analysis as to why did two fail with relatively close together. That work is going on. I expect to have the root cause analysis within a week. I have a draft root cause analysis now, but it's not done. We have working questions with the supplier on this, but no question that this was a mechanical failure.
So mechanical failure such as what the IRS experienced is not unique to the IRS. It happens to many organizations. In fact, there was a highly publicized mechanical failure with the New York Stock Exchange, which was similar. They went offline for a while to repair it. So I feel that there's a little bit of unfair or unequal treatment and maybe a little bit of a major focus on the IRS and questioning of the IRS for a long time that is not the same treatment that other organizations that handle a great number of filings experience. So I just wanted to point that out. The failures were very similar for the stock exchange and the IRS, a mechanical equipment failure. In any event, my time has expired, and thank you for your testimony today.
Thank the gentlewoman. We'll now recognize the gentleman from North Carolina, Mr. Walker, for 5 minutes.
Thank you, Mr. Chairman. Thank you, panel. Appreciate you being here today. I want to go back to something that I heard a little bit earlier. First of all, I want to talk about something that Commissioner Koskinen has said repeatedly. His quote says, "I believe that the underfunding of the agency is the most critical challenge facing the IRS today." He has made this comment pretty much in several different speeches, where it's tax policy conference or other places, where he's pretty adamant that that's a major issue. But something said earlier by one of my colleagues, I want to go back talking about the systems that you said that were dating back to John F. Kennedy time, I believe was the comment. It wasn't so much the application as it was the system. Would you repeat a little bit earlier and go into that for me just a minute?
Certainly. What they built back in the 60s for implementation in the 70s was a system design based around the technology that was available to them then.
Sure.
That design still exists, even though we're running the application now with much more modern underpinnings. That is these enterprise server that we just discussed with the Congresswoman.
Sure.
The actual design of the application is still built upon that 1960s approach.
But I appreciate you clearing that up, but that's not what Commissioner Koskinen said. what he said in his ploy to try to get more funding, more than the $11 billion already. He said, we have many applications that were running when John F. Kennedy was president. Do you agree that is that an untruthful statement?
No, I think that's true. The application, individual master file and the business master file and a number of those other clearly legacy applications, while some of the platforms they run on have changed, and the code's been updated numerous times due to legislation, the programming language is still the one that we had then, assembly language.
Well, he seems to be disagreeing with you on the code as well, because he said the code has been out of date so long, it has the unintended effect to keep hackers from hacking in. So whether is that just something he's not technologically current with that? I mean, are you running code from John F. Kennedy? Or because it seems 50-something years ago, where we're still running those kinds of systems and we're still operating with that code. Is that correct?
There are elements of the code that exist back that far, but the state
Talking Cobalt, Fortran, what are we talking about here?
Yes, COBOL programming language code, assembly language code is the principal engine. While we've modified it numerous times, particularly with legislation, the fact of the matter is that system was designed and built in the 1960s to start running in the 70s. So, I believe that the Commissioner is correct.
Okay, let me transition when I've got some time left. I'm going to go back to Form 3210 that was filled out authorizing the destruction of Mr. Maruka's hard drive. If so, if that was ordered, who authorized the destruction of that hard drive?
What would have happened would be that what I'm going to say presumed happened was whoever was checking out Mr. Maruka from the IRS would have called the IT organization, filled out a request to say, take his IT assets and follow the normal disposition procedures.
Did you assume that would have happened? Why was Mr. Maruka's hard drive not covered by the litigation to hold the IRS put in place? Why wasn't that? Why didn't that cover that?
At the time, he had left before that particular litigation hold was put into place.
But did he take his stuff with him? Did he take the information with him?
But it had already been entered into the process of disposition.
Well, so what happens when he leaves, when an employee leaves? Do their records get destroyed like this? I mean, what happened? Who made the decision? Who authorized that to destroy what he was working with?
I'm sorry, I really am not understanding your questions.
His hard drive, okay?
Pardon me?
Mr. Maruka's hard drive, who destroyed it? Who authorized it?
That would have followed the normal IT process of dispositioning of old equipment. And in that sense, the authorization is the IRS process.
And is there a timeline for how long an employee leaves that hard drives are destroyed? Is there a standard on it?
No, there is not. It follows.
So it's up to discretion.
There is a lot of discretion. There's a number of steps that are followed as to where it goes, because we have shortfalls in our staffing. Oftentimes, machines can sit around before they are disposed of. They may oftentimes even get so stacked up until someone gets to it.
His didn't get stacked up. Mr. Chairman, my time's expired.
Thank the gentleman. Recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Mr. Chairman, I only have one question. According to a September 28, 2015 Inspector General report, the IRS spent $139 million in 4 years on upgrading its workstations from the outdated Microsoft XP to Windows 7, but you still missed the Microsoft April 2014 end-of-life deadline. I think you understand that using a supported version of Windows is critical to securing data. Yet, according to a TIGTA report from September 28, 2015, you've got approximately 1,300 workstations that you either can't locate or you confirmed is running an old operating system. My question is, where are you on locating those workstations and getting them updated?
I think there's a number of questions in your statement, sir.
Well,
I'll try answering each one.
Well, just answer the one where you are on the status of locating those workstations. in
Once
updating the software?
we got support from Microsoft to go beyond the original expiration of XP, so we were not taking a risk with those particular workstations. Second, we took them off the network so they would be isolated and would not therefore be, would not be possible to hack into them through, I'll say, anyone who had access to the network. Where we are with the actual remaining numbers, if I recall correctly, we're complete. I'd have to double-check that, sir, but I can get back to you.
Could you inform the committee where you are on that? And I'd like to have that answer in 7 days. Can we do that?
Sure.
Mr. Chairman, I will yield the balance of my time to the chair.
Thank the gentleman. Mr. Mulholland and Mr. Tribbiano, it's May of 2013. TIGTA issues its audit, and you issue an internal preservation order that is extensive. It is capped with, quote, in other words, retain everything to do with email or information that may have been stored locally on a personal computer. It's pretty broad, but also very definitive. Did you ever rescind that order?
Is that oh.
That's a yes or no question. Did you ever reverse that order?
I changed the order with, as I tried to explain earlier, with the TEGE situation, where we had to start using some of the hard drives that we were saving.
Can you provide that?
To implement Windows 7.
Will you provide that to this committee?
We'll provide which list, sir?
When you rescinded that, send that to this committee. Fair enough?
I will.
Thank you.
Yes, sir.
Mr. Tribbiano, did the IRS ever change that or rescind the order that Mr. Mulholland had put out to preserve?
Not to my knowledge, sir.
After the issuance of that audit, did the IRS put any new procedures or policies in place regarding the preservation of emails, hard drives, or anything to do with people's interaction with computers?
We started, that was during the time period where we initially started the capstone project, sir.
Okay, you started a project, but was there any change to the internal functionality of the preservation of computers, hardwares, emails, that sort of thing? What changed?
Sir, I was not there. I'd have to go back and look at
Mr.
Killen, what changed?
So following those events, again, in late calendar year 2014, early calendar year 2015, we implemented the capstone approach for our senior-most agency officials, and so that
all government records. You don't have to be a senior-most official at the IRS to generate a record that needs to be in compliance with the Federal Records Act or to be in compliance with FOIA. I want to know, after TIGTA had issued their report in May of 2013, what did the IRS do internally to preserve and protect the records that they should have been protecting in the first place?
Well, Mr. Chairman, I think that does represent a fairly substantive change. And
what does?
Ensuring that, well, first of all, implementing the capstone approach. You know, we had significant consultation with National Archives.
Do you feel it was fully implemented?
The capstone process that we initiated with our senior officials, yes, that has been fully implemented.
So why, if the policy's in place, why was Mr. Maruka's information destroyed?
Fair question. It's an issue of timing. Because we implemented the capstone approach in actually late December 2014. Mr. Maruka had already left the service by that point.
So it takes you more than a year and a half to implement a new policy. How hard is it to just save a hard drive? I mean, how hard is that? How expensive is that? How much does a hard drive cost? Do you know?
I'll defer to Mr. Mulholland on that.
How much is a hard drive? You want 2 gigs of
100 to 250, depending on the brand.
Yeah, we're talking about $100 here. And they got a $1.7 billion issue with Microsoft, and you all went out and destroyed something that's maybe $100. Mr. Tribbiano, you had to issue a new policy in 2016, correct?
A new policy was issued in 2016.
What does that policy do?
We will not destroy any hard drives or mobile devices for any of parting IRS employees, and we will copy the hard drives digitally to a server.
Congress has been investigating the IRS since 2011, and you're just now getting the memo to start preserving things in 2016? Why does it take almost 5 years to get the message that you shouldn't be destroying things? Why does that take so long?
Well, sir, I mean, we have a records retention policy.
Yeah, but you didn't follow it. You did not follow it. Mr. Maruka's stuff was destroyed, and it shouldn't have been. It was only because, and you're misstating the facts, by the way, because there's another case that they actually copied Mr. Maruka's. Then they happened to find that. Why? I mean, I find it totally unbelievable. It truly is an unbelievable set of circumstances. 24 to 48 hours after this committee issues a bulletin that we're going to have a hearing, and then suddenly you find the information, and the Department of Justice had gone to the courts and said this stuff had been inadvertently destroyed. But then you actually did find it. Can you see why we have zero confidence in the record retention policy and the ability to execute on it?
Well, sir, you said that I misled you, and if that's the case, that wasn't the intent, so I just want to clarify that. We did find those records, and we found it because of another litigation hold. I thought I made that clear in my opening statement. It wasn't because there was some other thing. It was pure coincidental that we had another litigation.
And coincidental, in 24 hours after I issue a notice that you're going to have to come appear here, suddenly you do find them. That's what's unbelievable. You had gone to the courts via the Department of Justice and put it on the record that you didn't have them. That wasn't true, was it?
At that time that went, it was true. Yes, sir.
It was not true.
Well, in hindsight, it isn't. But at the time that we went to them and said we might have an issue here, it was true. When it was found that we did copy it for another litigation hold, we're correcting it. We found that there was another litigation hold.
Okay, the gentleman's time has expired. I now recognize myself, or recognize Mr. Carter for 5 minutes.
Thank you, Mr. Chairman. Mr. Milholland, help me out here. I'm just trying to educate myself. What's the timeline between when an employee leaves the IRS and when their hard drive is erased?
Yeah, that timeline can vary from immediate to 6 months.
What determines that? What determines the variation?
Where the person is when they leave. For example, if you're
You mean what hallway they're in?
Almost what office they're in. For example, the equipment if it's picked up by IT, has to be shipped to another location. But if you're in the D.C. area, for example, it might happen very quickly and such. Well, we typically send these devices to a particular data center for the degaussing once we separate the hard drive from the rest of the PC.
When was Mr. Marika's hard drive erased? What day?
We know. Would you cover that? The
Sure.
Deputy Commissioner can answer the details, but
Well, we don't know the date, and I think that's what the problem is. We know we sent it or consolidated on August 5th. We picked it up from the manager. We consolidated with other hard drives and other laptops, and we sent it to our Memphis facility. It arrived in
Now,
Memphis.
where was Mr. Maruka? Because you said Mr. Milholland did it depending on what office he was in. Which office was Mr. Maruka in?
Go ahead.
he was in D.C. as I
He was in
understand
D.C., but so you just said if he's in D.C., it ought to be pretty quick.
It could be, depending again on the process being followed and the staff that we have to do that work. If there was an intent that we say, hey, we could reuse this device very quickly, then at that point we'd separate the hard drive from the rest of the platform and put a new hard drive in. And
But in the case of Mr. Maruka, you don't know what day it was destroyed?
No, sir. It was sent down to the Memphis facility, and it was stored down there with other laptops and other computers that were marked for disposal.
Okay, so where it was sent down to, do they have a record of it? Can you call them and find out? I mean, surely they keep a record to tell you, okay, we destroyed this hard drive this day, this one this day?
No, sir. What we keep a record of is the asset. Once we separate the hard drive from the rest of the computer is sent off for salvage by an outside contractor.
Okay, I'm not worried about the rest of the computer.
I'm
I'm
just
worried
saying
about
that-
what gets erased. It would just occur to me, or it would appear to me that you would have a day on there, but somebody would keep a day that said that this is the day it was erased.
Not necessarily, sir, because we don't view it as a major asset at that point. It's disposition. We have flagged it for destruction. It's sent into the system, okay. This
Do you
scheme-
ever consider it to be an asset, an important asset?
Once it's flagged for disposition to be destroyed, no.
Okay, and this is even after we've had the experience with Miss Lerner, and with her hard drive being destroyed and being wiped out. Even after that, we still don't have in place when exactly we destroyed it. We still don't know. So you're telling me that's a matter of policy?
It's a matter of the workload and the resources we have to do that task.
The workload and the resources.
That's, sir.
So everything is determined by the workload and the resources, not by its importance.
Well, the importance is that we had already decided that this particular drive could be, in fact, be destroyed. At that point, it's deemed worthless. So it's stacked up with other hard drives.
I just find it to be a very poor excuse about resources. I mean, it would seem to me like that you would have been really on your toes, especially in light of what has happened in the past. It would seem to me that you would want to absolutely know when a hard drive was destroyed or wiped out. I mean, you see where I'm going here. I'm just getting the impression from where I'm sitting, it looks like the IRS is just taking the attitude, hey, we're above the law here. I mean, that's what it looks like to me, and I can imagine what it looks like to a regular citizen who is being audited by the IRS. It is really confounding to me that we don't keep better records than this. It would appear to me that the IRS, in light of everything that has happened in the way of hard drives being wiped out, that your policy would be better and that you would be keeping better records. And so you can understand why the general public thinks, well, they think they're above the law here. I'm just flabbergasted by this. Mr. Chairman, I don't know what to say except that I hope that you will take this as a lesson and understand that, you know, there are people out there who are being audited by the IRS who feel like they're being targeted, feel like they're being treated unfairly, and feel like the IRS thinks they're above the law. So in instances like this, you can understand why they feel that way. This is unacceptable. Mr. Chairman, I yield back.
Thank the gentleman. Myself and Mr. Jordan have just a couple other questions, and we're going to wrap up the hearing, and members are advised that we have votes on the floor soon. Since when has the IRS preserved all of its internal emails? When have they started? When did they start to do that?
So our internal email, again, there's nuances to it.
You're either saving them all or you're not. Do you save all the emails?
All our internal emails are not being saved but we have the plan in place in order to get there. All of our emails for our senior-most officials are saved. We've actually had substantial interaction with NARA, so I do want to get this point across that NARA has.
Hold on. I guess I want to get to this point. You still, to this day, do not preserve all of the IRS emails internally. You do not save those.
May I answer that question,
Yeah.
Mr. Chairman? The answer is we save them on our backup tapes and have since that original email that Representative Jordan was referring to.
Then why does Mr. Killen just tell me that we don't do that?
I think he was referring to all the
No, he can tell you what he's referring to.
I'm sorry, sir.
Mr. Killen, you just told me that they don't preserve all the emails.
Well, I think that there's a general difference there's a distinction between what we would have preserved on the network and what we have preserved via backup and disaster recovery process. And I think that's the distinction that Mr. Mulholland was going to make. With respect to, because I do want to be clear about this point, the directive that we are under is that all email should be in an electronically accessible format by the end of calendar year 2016. That is the plan that we have implemented. That's the plan that we're on the trajectory to meet. But in the interim, and again, this has all been a process that we've worked with NARA on. In the interim, our senior-most agency official emails are being preserved, and that's sort of I talked about this multi-pronged approach that we've implemented.
Is there anything, Mr. Milholland, that you would disagree with that he just said?
No, sir. We are going to be NARA compliant.
Here's the problem, okay? Here's the problem with the testimony. This is testimony from John Koskinen of June 23rd, 2014, and here's what he says. I would note, however, since the investigations into the application process for 501c4 organizations began in May of last year, the IRS, here it is, the IRS has saved backup tapes for all emails on the IRS's servers, which includes tapes for the 6 months preceding May of 2013. And you're telling me that isn't true. And that's why we keep coming after the IRS, and that's why we're not going to let go of this. I recognize the gentleman from Ohio.
Sir, can I make one statement, please?
If I could, Mr. Chairman, this would be my third time, and the right fine gentleman from North Carolina hasn't went, so I just have two questions anyway, Mr. Chairman.
I'll yield to the gentleman from Ohio for two questions and then take up the ballots. How about that?
Okay. So, Mr. Milholland, when you, on March 4th, when you discovered the tapes are destroyed, March 4th, 2014, the backup tapes are destroyed, you testified in the TIGTA investigation that you were blown away by the fact that your directive wasn't followed. What did you do then? Did you, and I guess in specifically what I'm asking is, did you have any conversations with your direct report, Mr. Tribbiano's office, or the person who runs Mr. Tribbiano's office, and or Mr. Koskinen?
At that particular time, the TIGTA investigation was still going on, so I was not allowed to talk about the conversation I had with TIGTA until after the report was released.
But when you, okay, so when you learned that the tapes had been destroyed, your directive wasn't followed, you had no conversation with the commissioner?
No.
Have you had, subsequent to when it became public, have you had conversation with the commissioner?
Yes, sir.
About this specific issue?
In the general conversation around backup tapes, yes, sir. And that's what I was trying to correct earlier. We have retained backup tapes for indefinitely since that email was issued. Those were off of the Exchange system, which is the primary email system of the enterprise.
I get that, but I'm asking more specific. Did you have a conversation with Mr. Koskinen and say, look, I gave a directive, it wasn't followed, 422 tapes, backup tapes were destroyed, we no longer have those records at all? Did you have that conversation with Mr. Koskinen?
No, I did not specifically.
Okay. One final one here. In the opening statement, you talk, this is Mr. Maruka's situation. His hard drive was designated for erasure before the issuance of the litigation hold. Is that right?
Yes, sir.
Okay. Yet you said later that his data was, in fact, though, backed up because you had another litigation hold.
Yes, sir.
So why didn't the previous litigation hold prevent you from destroying the hard drive?
Because the data was backed up and it was sent to the digital. What happens is when the attorneys request the information, it goes into their I might be calling it the wrong thing, their e-discovery system where they can access the data and do whatever they need to do for discovery purposes.
And just to be clear, a litigation hold doesn't trigger preservation of hard drives, that only triggers it goes to a backup?
No, sir. It preserves the records for use in the litigation.
And the best record would be the hard drive, not the backup, but under this situation, you didn't do that?
The records are what was on the hard drive and backed up at that point in time.
Will the gentleman yield?
Sure.
Then why did the Department of Justice, on behalf of the IRS, go to the court and say these records had been destroyed?
Because at that time that we notified the Department of Justice, we thought that his hard drive, but we didn't know that we had the backup of that hard drive for that other litigation. So we told the Department of Justice that we did not have the hard drive.
And you have no records of what you destroy and when you destroy it, correct?
That is correct. What we know is that on 10/27, it was received in Memphis, and between that period and the period of April 16th, I believe, when the shell of the computer was delivered to the third-party vendor. It was during that time period.
How convenient. You have no records of what's destroyed and when. And yet you require every American to keep all their records. That's what's so fundamentally wrong and screwed up with the IRS. That's just wrong. And there are a lot of good people that work at the IRS, but you know what? You go after Americans, but you don't take care of business at the IRS. It's just wrong. It's just wrong. And it causes mess. We're talking about a $1.7 billion case, and you guys can't keep track of what you destroy and when you destroy it. How hard is it to put a log entry in there, destroyed this one on this time? Like, how long does that take? I mean, you go to Best Buy and buy something off the shelf for like $50. I just don't understand that. Do you have an answer for that?
I don't think it would be that difficult, sir.
Then why isn't it done?
I can turn that over to Mr. Mulholland, who runs the IT shop and runs those procedures, and ask what that would mean from a staffing perspective and from a documentation perspective. But I think what Mr. Mulholland alluded to was that it is an asset, and it's kept into the assets, and it's kept into the system up to the point where it is marked for disposal. And at that point, it stops.
Yield back to the gentleman from North Carolina.
Thank you, Mr. Chairman. Mr. Mulholland, let me tell you the issue that most Americans have with this. Storage is cheap. I mean, we've gotten to a point, even storage of millions of records is really cheap. We've gotten to a situation where it would have been so much easier when the first hearing happened, not 24 hearings later, but the first hearing, to say, you know what, gosh, we're going to have this problem. We better preserve everything. What precluded you from doing that? From preserving everything. At that point, when Lois Lerner first came in here and took the fifth, what stopped you from saying, let's just preserve everything?
I can't recall the subject ever coming up, sir.
Now, you can't recall the subject coming up. It was on the headlines, I mean, almost every major newspaper, and the subject didn't come up about keeping it, and yet your testimony today says that you're NARA compliant. Would you care to revise your statement? Because I don't believe that you're NARA compliant at this point. Having the National Archives underneath my subcommittee, I would probably beg to differ with that. So would you like to revise your?
I would ask that Mr. Killen respond to whether or not we're NARA compliant, since that's his area of expertise.
All right, so are you NARA compliant?
We are generally NARA compliant.
No, there is a yes or no. Generally is if I'm speeding and I generally go below the speed limit, I don't get a ticket. But only those couple of times that I go beyond the speed limit, I actually do get a speed limit ticket. Tell me, are you compliant or not?
Well, I have to speak to the wording of the report. I mean, because we've had NARA reviews, and so certainly we have opportunities for improvement.
Then you're not NARA compliant.
But on the whole, NARA has opined that we are generally.
You're making progress, I think is what they're saying.
We're certainly making progress, and we have opportunities.
But today, you're not NARA compliant, which means that all communication would be preserved. Would it not?
We certainly have work to do.
Okay. So if you have work to do, then you can revise your statement that you're NARA compliant, because obviously you're not.
In that sense, you're correct, sir.
All right. So let me go a little bit further, and I'm going to piggyback on what the chairman talked about. Mr. Killian, why is it taking so long? I mean, why is this taking so long for us to get it right? Why December of 2016?
Well, I think the 2016 date is predicated on an OMB directive that does not extend to just our.
So it's OMB's fault.
No, it's not. It's not an issue of fault. It's an issue of what is the origin of the December 2016 date. And the origin of that December 2016 date is the OMB directive that says that all federal agencies should have email in an electronically accessible format.
So it wouldn't have anything to do with the change of administration.
I couldn't speak on that. I don't.
Well, do you not find it curious that December 2016 and administration change would happen within 20 days of that date?
I really can't speak on that.
Okay, all right. So let me go on a little bit further. Because part of this whole hearing process has been other types of communications. And y'all have been very careful to say email communications, but there are a number of other electronic communications that go on the system and go back and forth. Is that correct, Mr. Milholland?
Are you referring to instant messaging, sir?
Yeah. I mean, don't you have substantial communications among some senior level people at the IRS that happens outside of email?
Yes, sir. There's obviously phones.
Okay. How about on text messages or instant messaging?
Actually, I don't actually.
You don't? Does anybody there use instant messaging?
I don't, sir. It's on our system.
Yeah, our gray hair probably throws us away, but I'll go to the end. Mr. Killian, I'm sure you do, don't you?
I certainly do.
I figured you would. So it may be a generational thing, but if we have, Mr. Killian, do you use that instant messaging to do anything more than, is it time to go to lunch or a coffee break? I mean, do you conduct business on instant messaging?
Generally speaking, I do try to be careful about what I.
Has there ever been a case where you've used instant messaging for business?
I'm sure there probably has been.
Yeah. And so here's the issue, Mr. Milholland, and I'm going to finish with this. Storage has become cheap. Backup tapes are becoming a thing of the past. I remember backup tapes, and I don't understand why, with the amount of money that we're spending, that we're still using backup tapes, unless they're just such legacy programs that we have to use the backup tapes for storage. We're committed to providing the resources. What we haven't seen is the commitment to really get serious about preserving everything like Commissioner Koskinen has said he would do. And until we see that, we're going to take issue. Does that make sense?
I understand you, sir.
All right, I'll yield back.
I thank the gentleman. The committee stands adjourned.